Some questions.
Yeah, I'm back. Okay.
Okay. I will. Okay. Somebody said, can you go through the section 19 of the Trading Transaction Act again? Okay. Okay. So I will stop sharing these. Good. Now, so section 19 is on reception. Reception of an electronic record. And there are two subsections on this. One deals with designated information system. The other one deals with non-designated information system. And I explained that if you designated the information system, then once it leaves your system and hits, so once it leaves the sender's system and hits the recipient's information system, he has received it, regardless of whether that information went to spam or not, regardless whether he has read it or not. That's the first part of the rule. The second part is that if the information system to which you are sending the electronic information is not designated, in order for the addressee to be held to have received the information originated from the originator, the addressee must retrieve. So that's why I said you should read, when you read it, you read section 19, focus on the word. It says retrieves, so it is in present continuous. It's not about the addressee ever having retrieved. That's why I use my Hotmail account. I don't recall anything about that account. I forgot about using it since the late 90s, you know, when we were in school in Legon. And so if you send anything in there, I cannot, by the rules, be deemed to have received that information from you. So this is just the explanation of...
okay, so maybe let's allow Ashetu to come in. Ashetu, you can mute yourself. Ashetu. Ashetu, you can mute yourself, or your hand is up by in a mistake. Okay. If you are not, then let me invite Bex. Bex, you can mute yourself.
Good evening, Doc. Good evening, sir.
Good evening.
Please, I wanted to find more clarity on the rule of acceptance, whereby if there's a certain reward for maybe giving or doing an act, and then that communication was not heard by you directly, and then you perform the act. I want to know the position on that one. It looks like I read about two different positions. I want to be clear on it. Whether if you didn't hear the message directly by yourself and you perform the act, you qualify to take the reward or not.
You mean unilateral offer?
Not unilateral offer per se.
Not necessarily unilateral. I understand her question.
Right.
Not necessarily. Yeah. Now, so the important thing is this: the action which is being put forward as an acceptance. The question is whether that action is in response. Whether that action is in response to an offer. Because if you are not aware of the offer, if the information hasn't come to your knowledge, how are you accepting it? I suspect that the case you're talking about, the information about the existence of the offer came to the offeree before he had given the information that he gave, leading to the arrest of the criminal. So the important thing is the acceptance in response, or not. Let me not say acceptance. Is the expression of assent, which is being put forward as an acceptance, is it in response to something? Because no matter how you look at it, if you are not aware of an offer, you cannot be accepting that offer. That's my understanding of it.
Okay, so that's a quick one.
There is a question on from Aisan also. It says, what is the meaning of designation? Does it mean the system should on offer letter contract? No. Designation simply means providing the information system. An information system here, you're simply talking about your digits or letters. So for instance, your number, your telephone number, your email address, principally. So if you give your email address to an offeror, or let's say you give your email address to a potential offeree to communicate his expression of assent, then you have designated that email address. If it's in a written contract, you can say that for you to accept this offer, please send your expression of assent to this email address. So there it is designated in the offer in black and white. But of course, it doesn't have to be in black and white. You can have, viva voce contract as well. So it's just about providing the information system. Okay, so now can we try our hands on some multiple choice questions, and then we go to the next slide, set of slides?
Yes.
Okay,
I like that.
All right. So I will share. I will share. Okay, can you see the questions?
Yes, I can see. I can just see that you have opened the, what do you call it? Is it the dialogue? You've opened
It's
like
a word.
dialogue box, right?
It's a word. Can you see it?
No, the word has not come yet. You rather see the folder from which you open the thing.
Okay, you know what? Then let me stop sharing. I'll stop sharing.
No, you know something?
The word. Okay.
Open the word. You open it.
Can you still see the folder?
If you have just open the word and then start sharing again. It will come.
Can you see it now?
You started. Yeah, it's come. It's come now. Yeah, it's quite clear now.
Okay, good. Okay, good. All right, good. Now, so question 2, for instance. Question 1 is a recall. It's a recall question. So let's not worry about question 1. So question 2, for instance, what's the correct answer? Section 5(2)(a) of the contract, blah, 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 is not inconsistent with the decision of the court in Dunlop Pneumatic Tire versus Selfridge. What's the correct answer?
If you know, put up your hand or write it in the chat.
The chat, yes. Is it true, false, either true or false? True and false? It depends. What does it depend on if it depends?
Listowell, you can talk. Then after that,
It's false.
yeah.
It's false.
It's false.
Explain.
It's false.
Explain why you are saying it's false.
Okay, so in the Dunlop and pneumatic suffrage,
Yes.
It does not confer benefit on third party, but in Ghana, the act has been amended. I mean, we have an act, that's the Contract Act 25, section 5 to 9, confer benefit on a third party when it comes to privity of contract. So when you say, the question say is the contract, okay, said with the decision of, it's not inconsistent with, it is inconsistent with. Is that it is not inconsistent with the decision of the court in the Dunlop pneumatic tie versus consistent. You have to be the same.
Okay, so now your explanation, it's a bit okay, but your answer is wrong. So the explanation is not tallying with the answer.
Wow.
Yes, the answer is wrong.
Okay.
Yeah. So let's hear Senam. Senam.
Yeah. Sanam, you can unmute yourself. Sanam, you can unmute. Oh. Sanam, you can unmute yourself.
Good evening, sir.
Yes.
Good evening.
At a point, I was trying to side with Listo, looking at the wording of the sentence. It's not inconsistent.
Yes.
I think I side with Listo that it is false.
Okay. Why? Why? Well, now, so let me just. Can you mute yourself now, because we are getting a feedback.
Yes.
Oh, sorry. The question simply is whether both section 52A and Dunlop are saying the same thing. That's the question. Is section 52A and Dunlop saying the same thing? And the answer is yes, they are saying the same thing. That's all. It is not inconsistent. Are they saying the same thing? Are they consistent? Do you understand now?
Yes, I do. I do.
Good. Good. So I know that it is the not inconsistent which threw you off that a little bit. But you know, you need to be mindful of it.
Very well.
Yeah. Now, question 3.
Mr. Amizu, let me make this house.
Question 3.
Mr. Amizu, let me make this housekeeping announcement. To facilitate
Joseph sent his WhatsApp, sent his acceptance to Mary's offer via email.
Mr. Amizu, can you hear me? Can you hear me? Hello? Can you hear me? Oh, I think this internet.
Doc, the network is
yes, I wanted to
not
say
good
that
from your end.
I wanted to say that I have released everyone, but I'm just advising.
We can hear you.
Yes, I'm just advising the students that if you want to talk.
Yes, we can hear you.
Yeah, just unmute yourself. When you finish talking, mute yourself.
I can hear you, please.
Yeah, I'm just giving the advice that when I've released everyone, so if you want to contribute, just mute yourself as soon as you finish mute yourself back so that you don't get the feedback into the class. Instead of we releasing you every now and again. But just let us explain ourselves. If you are not talking, then you mute the mic. Thank you. Please continue.
Good. Thanks. All right. So question 3. Will somebody read it very quickly and give us an answer?
Joseph sent his acceptance to Mary's offer via an Outlook. Mary saw the email with the subject reading acceptance of offer, but could not open the attachment before Joseph recorded. Which of the following is true? A, there was an agreement as the acceptance was received according to section 18 of Act 772. B, there was an agreement as the acceptance was dispatched according to section 19. C, there was no agreement according to section 18 of Act 772. D, there was no agreement according to section 19 of Act 772. E, none of the above.
Okay, so what's the question on? Can you explain the question to us and give us the answer? So this is an attempt to accept an offer through the electronic means, through an email. Okay, so the email was sent. The offeror saw it, but then it was recalled. He saw the subject, and then it was recalled. So he couldn't read it any longer. So what's the correct answer to the question? What's the correct answer?
B.
It's B.
B. So there was an agreement as the acceptance was dispatched according to section 19. Now, if there is something called wrongest, that is the wrongest answer. Don't mind me. Now, what I mean is that, first, section 19 is on reception. But B is saying dispatch according to 19. That's what I'm saying. You see, so there's a lot of confusion in that answer. You understand?
Sir, I'll take E for number 3.
E for echo?
Yes, sir.
Oh, no. It is one of the above. It is not none of the above.
Sir,
Yes.
I go for A.
A. There was an agreement.
Yes.
If you say there was an agreement, what was the tenor of the expression of assent? What has been recalled? What was the rendition? Let me say it this way. Because you see, the thing was recalled,